good afternoon. I hope everyone's well in this lovely sunny afternoon. My name's Anne Kingsley. I am the Professional Support Lawyer Lead for Local Government at Lexis Plus. I'm delighted to welcome you to the latest of our Local Authority Insight series in association with Local Government Lawyer covering taxi licensing today. With all that said, I'm going to introduce our panelists today who you all know. Stephen Turner is the lead on all things licensing at Kingston upon Hull and has been a solicitor there leading all aspects of their licensing offering since 2004. James Button is a solicitor in private practice with a niche practice that's been open since 1996, covering all aspects of licensing law and has acted for many public authorities. So without further ado, I'm going to hand over to them and for them to have an engaging conversation that we will very much enjoy eavesdropping. Thank you very much, both.
Thank you very much, Anne. Good afternoon, everybody.
I'm delighted for me.
Delighted that you've all thought it's worth giving up your lunch hour to listen to us, and I hope at the end of it you won't be disappointed. When this was being planned, we were told that this would take the form of a fireside chat. The weather doesn't really lead to having an open fire. We're not in the same place, and more importantly, we haven't got the pint of beer that we usually have when we do sit and have a fireside chat.
Quite right.
So the idea is we're just going to discuss a few areas that are of interest, or we think they're of interest, and then really throw it open and see if anybody wants to ask any particular questions. So shall we kick off down the list? Stephen, do you want to say anything before we start?
Other than just repeat, good afternoon, everyone. It's great to be here, and I'm looking forward to this session.
Right. There is a proposal that the government has put forward as part of its Levelling Up programme and it's a fairly early days, they're going to consult on the possibility of moving taxi licensing, that is hack and private hire licensing, using the term taxi generically, from districts to either combined authorities, or if there isn't a combined authority, county councils. The rationale behind that has not really been particularly well explained, but it seems to be that if you have fewer borders, there will be fewer cross-border problems. So that was one of the things we were going to discuss. Now, as I understand it, the consultation, well, as I was at the National Taxi and Private Hire Association Expo yesterday in Milton Keynes, and Paul Elliott from the DFT said that the consultation on this is coming shortly, which is DFT speak for some time, at some point, if we're lucky. But I just wondered, what are your views on this, Stephen? And then I'll say what I think.
Yeah, it was a bit of a surprise to me when the Levelling Up bill was a bill, and it was something that I hadn't really considered previously. I've got mixed views on it, some of which are fairly obvious points. Jim's mentioned one already, and that is fewer authorities actually licensing drivers and vehicles means fewer borders and all the problems of cross-bordering that go with them. I think there's something like 270, 280 current licensing authorities, and in a previous conversation Jim said he reckons that it could come down to about 70 or 75 if the proposal goes the distance. That's quite a remarkable change and affects the borders. It also means that a single authority has a much greater geographic area and therefore more drivers, more vehicles, more operators. So there are staffing implications that could be quite significant. When you have staffing implications, you also have the potential for loss to the knowledge base. And that rather concerns me, because a lot of the public think that licensing is like buying a stamp. You pay your money, you get your license. But I suspect that everybody in this room realizes it's the absolute opposite end of the spectrum to that, and is probably one of the most complex aspects of regulatory law that any local government lawyer has to deal with. It is a good thing in this way, and that fewer authorities mean fewer policies, and therefore it assists us on the road towards what we dearly want, which is national standards, or should I say now, more national standards. That is probably, in my view, the best thing about it. I know there are groups of authorities that currently work together and cooperate in terms of policy making. You look at the group of authorities around the Tyne, and I think there are 7 or 8 involved there, and they have what amounts, I believe, to effectively a unified policy. It's the same in Greater Manchester, and there are some other groupings, which is a bit of a halfway house to what is now in the Act about reducing numbers. So it has pros and cons. At the moment, I'm undecided whether the pros outweigh the cons. I think Jim's probably a little bit further along the line, so I'll pass back to him at this point.
Thanks. Yeah, I mean, my feeling is that the advantages don't really strike me as being sufficient to justify that upheaval. There are still going to be borders, there are still going to be different policies, there are still going to be different approaches to application of those policies. I fully accept what you say, Stephen, that there'll be reduced opportunity for differences, and I think that must be a good thing. But the difficulties of trying to implement that in a local government environment where everything always seems to be in a state of flux, I think is just going to invite more problems than it's going to solve. I mean, the other thing is, realistically, you know, looking at it from a very small p political point of view, is it actually ever going to happen, bearing in mind the election that's going to come up? And I don't, you know, make any predictions as to the outcome, but again, we're in a state of flux. So my feeling is it'll be interesting to see the consultation. It'll be interesting to see how they phrase it. And as with all these consultations, I think what I'd do is encourage everybody to respond to it. Just on the topic of consultations, if I can just go off on a slight tangent here, there is a consultation at the moment from HMRC on the VAT implications of the Sefton decision. The Sefton decision is the High Court decision for the law outside London, which has concluded that a contract for a private hire journey must be between the hirer and the operator, with a then second or secondary contract between the operator and the driver to provide that service. That was the same finding as the High Court in London. So at the moment, England, the rest of England and Wales and London coincide, but that is going to the Court of Appeal, the English one, the Sefton one, and being heard in the beginning of July. The government has done its usual trick of jumping the gun instead of waiting for the outcome of the Court of Appeal decision, and are consulting on the VAT proposals. Now, you might all think, well, Struth, I'm not a VAT lawyer, this has nothing to do with me, which I must admit was my first impression as well. But there are some very interesting questions in there, the best one of which is, should there be a system whereby a passenger can contract for a journey directly with a private hire driver? And the most entertaining question is, can you articulate a way in which a passenger could contract directly with a private hire driver without achieving single-tier licensing? And I have to confess my answer to that is no, I can't articulate that. But the point of what I was going to say is it obviously is an important consultation. Please don't overlook it simply because you think it's to do with VAT. Yes, a lot of it is to do with VAT, but there are some quite important questions in relation to private hire licensing. So I'd urge you all to have a look at that if you can.
It's interesting, isn't it? But the suggestion of reducing the number of licensing authorities and saying that will cure all ills, particularly the cross-border problems, it will reduce those and it will help with unification of standards. The cynic would say that's just an excuse for not creating brand new legislation to bring taxi and private hire into this century, not the one before last, which is where it seems to doggedly remain. And the other point, particularly from what Jim has just said, is that the Law Commission, as long ago as 2012, 2013, published, I think probably for the first time in their history, an interim report. I'd certainly never seen one previously, and an interim recommendation. And if the government thinks that what they've done with the Levelling Up Bill is a late excuse for not dealing with the Law Commission's recommendations back in 2013-14 and just kick it into the long grass instead, then I think it's a very poor effort indeed.
And in fact, just following up on that, there's an irony, I think, in the VAT consultation, because they actually refer to the work of the Law Commission, which, as far as I'm aware, is the only time the central government has referred to it in the last decade.
Yes.
So, you know, what if you stay in this game long enough, it all comes back round again, doesn't it? Well,
it certainly does. And I think, you know, the fact that we are in an election year it is perhaps part of the reason why they've put the consultation out now. And what's the closing date? It's August, isn't it? Early August.
8th of August, I think.
Yes. Yeah. That probably just gives them time to do something other than look at it and see the 3 replies they've got. So I back Jim's urging of you to contribute to that, because there are some interesting questions in it. But of course, whether it gets anywhere, we don't know. The Court of Appeal will do what the Court of Appeal wants to, as always. It will be an interesting read, will that judgment, because there is a potential, I suspect, for it to actually bring the long chain of Uber litigation to some sort of conclusion. I live in hope. I actually like Uber. I'm in Uber's camp, not literally, but I think Uber over the years have had an extremely bad press. And as far as Joe Public and the press are concerned, it's Uber that licensed the people that drive for them. Nothing, as you know, ladies and gentlemen, could be further from the truth. We do. So if there's a problem with an Uber driver who shouldn't have got a license, it's actually the fault of the licensing authority that issued that license. They made a perfectly valid decision, but probably on a completely different topic, on insufficient information or insufficiently accurate information in order to judge that individual's fitness and propriety in the way that it should be judged. I divert, I'm sorry.
Or possibly, and I can say this not as a local government officer and employee, on the day the members had some kind of meltdown, felt sorry for the bloke, and granted the license for what could only be described irrational reasons.
Right, the applicant must have had a moustache.
Or wore a tie.
Yes. We've seen
Yes.
them all.
Okay. Right. Which one do you want to go for next, Stephen? I'll leave it over to you.
Well, the segue is really to cross-border problems, isn't it?
It is really.
Yeah.
There's a lot of concern about cross-border activity. Some of you may be aware that you may be aware of a publication called Private Hire and Taxi Monthly, which is very much digested by the trade. And a couple of years ago, they did a series of 3 articles over 3 months, which were long-winded. But the gist of it was that the legislation prevents cross-border activity by private hire vehicles, and it's simply that local authorities are not enforcing the legislation. I know from experience that that caused some difficulties in local authorities, in particular one authority that I've done some work with. That was brought to the attention of the leader and the chief executive. Instant opprobrium placed upon the licensing team and the legal team as to why they weren't enforcing this law. Clearly, this was what the law said, because this article said so. And it's unfortunate because whether you like it or not, and I fully accept a lot of people don't like it, the way the courts have interpreted the 1976 Act for the last, close on 50 years now, is that a private hire operator can advertise their services anywhere. That's the Windsor and Maidenhead case. A journey in a booking for a private hire vehicle can be made by anybody located anywhere for a journey that can commence anywhere, travel anywhere, and finish up anywhere. So there's absolutely no requirement for that journey, that hiring, to start in, pass through, or finish in the district in which those licenses were issued. As a consequence, you can have an operator based in Wolverhampton dispatching a Wolverhampton licensed vehicle and a Wolverhampton licensed driver, legitimately undertaking a hiring in Hull, in Newcastle upon Tyne, in Brighton, anywhere you like. The problem, of course, with that is that the officers in Hull have no powers to deal with a vehicle and driver licensed in Wolverhampton. Now, to be fair to Wolverhampton, they have a lot of reciprocal arrangements with authorities where they authorise officers and so on, but it's by no means universal. And it's not just Wolverhampton that this happens. Now, clearly, the only people who are interested in where a local authority district boundary lies are people like you and I. As far as the public are concerned, yes, they may know who they pay their council tax to and who they pay their bills, but they're not interested in where the tax is going to take them. So there will always be movement across borders, especially in urban areas where you've got more than one authority, the conurbations. But over the last decade or so, this has undoubtedly exploded. And there's a lot of concern about what can be done about it. There is some information. There was a High Court case, the Delta and Knowsley case in 2018, where Knowsley tried to restrict the activity of a private hire driver by getting them to sign a declaration to the effect of, I'm only going to work predominantly in Knowsley, and if I don't, I will no longer be a fit and proper person. And to cut a very long story short, the High Court was having none of that and said, no, that's ridiculous. Somebody who is fit and proper in Knowsley as a private hire driver will also be fit and proper if they then move to Portsmouth. There is no difference. Fitness and propriety has nothing to do with the location in which that person either lives or works, which I think has to be absolutely right. Now, there was a throwaway line at the end of that judgment where the judge said, and this is, I was going to say almost sub obiter actually, that there might be an argument to try and limit activity placed on the vehicle rather than the driver, but he wasn't convinced, and he certainly wasn't going to pronounce on it, and it certainly wasn't part of the case. So that is the sort of judicial position. In the DFT best practice guidance, which has now got the really snappy title of Taxi and Private Hire Vehicle Licensing Best Practice Guidance for Licensing Authorities in England, which was published in November, paragraph 6.12 suggests that local authorities should have intended use policies in respect of taxi drivers. Now, when the DFT say taxi, they mean hackney. So they're suggesting that a licensing authority should require an applicant for a taxi driver license to declare that they intend to work predominantly within the licensing authority's area. The residential address provided by the application should be considered in assessing the likelihood of this declaration being adhered to when assessing an application for a taxi driver license. Well, that leads, I think, to 2 points. The first one is when you talk to the trade, cross-border, out-of-district, pre-booked hack work is significantly less of a problem and less common than cross-border, out-of-district private hire activity. The second point is that I have always been very wary about this idea of a restricted use policy. Whether you like it or not, and I know I used that expression before, the courts have made it clear that a hackney carriage can be used for pre-booked work anywhere in the country. That is legal activity. So once somebody has a hackney carriage proprietor's license and a hackney carriage driver's license, both of which must have been issued by the same authority, that person is free to advertise their services for direct contact with the driver outside the district in which they're licensed, just as much as they're licensed within the district. That is legal activity with those licenses that have been granted. And I've always been very dubious as to whether a local authority can restrict that legal activity simply because it is inconvenient to another authority in whose area the activity is taking place. So those are my sort of opening thoughts on that. And there is a possible suggestion which we'll come on to in a minute or two, Stephen. But what do you make of that?
Well, I'll try and put a different dimension on it, because you've looked at the technical side of it. What is the problem, going right back to basic principles, with private hire working cross-border? What we're talking about here is a transport system. And anything that tries to restrict the ability of a member of the public in Cornwall to get to Northumberland is not going to be very popular, or Tewkesbury and Blackpool. It doesn't matter. They want to make a journey and they want to pay somebody to take them. As long as the system they use is safe, as long as the vehicle they use is safe, as long as the driver is fit and proper, does it matter where that vehicle is licensed, where that driver is licensed, where that operator is licensed? Well, no, it doesn't. Many people say, as long as they've got the license. One cohort that says, yes, it does, is your local members and my local members, because they want to make the decision about what happens on their patch. And the thought of 250 vehicles licensed in Wolverhampton operating in Kingston upon Hull probably upsets 56 out of my 57 members. And the one who wouldn't be upset has just lost his seat in May. So there we go. So that's why it doesn't actually matter. But if you link your thinking on that with the last subject we talked about, i.e. the reduction in the number of licensing authorities. That proposal also takes a lot of the localism out of decision making as to what happens on your patches and gives it to members of a much bigger patch. So they've got a coordinated effect, if you like. There was another attempt, I think, to limit by looking at the way the vehicles were insured and trying to imply a hypothesis that if it wasn't insured, or it was specifically insured for where it was licensed, then that was the end of it, and it made anything outside unlawful. That attempt failed also. And there's been a very recent case, admittedly only a district judge in a magistrate's court, but in March of this year, in a case called 57 or Hall and 57 Taxis Limited against York City Council, there was a consideration of this whole issue, because York, and I'm sorry if there's anybody here from York, who I probably know anyway, as I've done a lot of training at York. York has a bit of a history of problems with operators and cross-border work and operators from outside the city. Who doesn't? They compromised an appeal a couple of years back on agreed terms. And then there was another claim by an operator who said that they had had conditions imposed on their operator's license, which was granted, but which conditions hadn't been muted during the hearing. And the first they knew about them was the decision letter saying, yes, you've got your operator's license. Oh, by the way, we've added this raft of conditions. And the raft of conditions basically was York's attempt to try and defeat cross-bordering into the city. The operator appealed and won, basically. And the district judge held that, first of all, the addition of those conditions in the decision letter was a breach of natural justice, one of those fundamental rules which I simply don't understand why people forget those so easily. And his other main criticism was that the proposed restrictive conditions about out-of-patch working weren't in any policy of that council. So how was an operator seeking an operator's license in that location for the first time ever to know that unless that if they wanted to use vehicles licensed elsewhere, drivers licensed elsewhere, and they held a license elsewhere, there was a whole raft of conditions that they would face if they tried it. If we conflate these two topics, then what we do need is the root and branch new legislation, because that can deal with everything. It could consider the provisions of the Levelling Up Act. It could consider the problems of cross-border working. But I go back to that fundamental. This is a transport system. And ladies and gentlemen, it took until COVID for taxi and private hire to be actually recognised as a transport system in this country. It had been repeatedly denied or ignored as part of the transport system. And it was in one of the sets of emergency regs, I seem to recall, that recognition finally arrived. It needs to change. It won't change under this government. And depending upon the result of the election, it may not change under the next one. I mean, it's only last year, I think, before any election talk started, that Jim was saying he doesn't believe that there'll be new legislation in this field until after he is retired.
No, absolutely.
So it certainly applies to me because I'm considerably older than Jim.
I mean, there's a couple of other points on that. The government, as a result of the working party that sat in 2017, I think now.
Yeah.
That put forward about 33 very sensible recommendations. The government decided to go forward with 3. National licensing database, which they argue they've got with the NR3S, although that only applies to drivers. But the other 2 things were national standards, arguably national minimum standards, and some form of cross-border enforcement. I was told directly by the Transport Minister in March 23 that wouldn't happen until after the next election. So again, it's anybody's guess whether anything happens. But I would just, if I may, put forward a suggestion that I've made, whereby local government as a whole can achieve national standards, and you can achieve national standards next week. There's an article about this in the Journal of Licensing. I have to declare an interest here. I'm the president of the Institute of Licensing, but I must also make it very clear that these are my views. They're not endorsed by the Institute. A principal authority is identified who will license all private hire operators, vehicles and drivers across the whole of England and Wales. Every other local authority stops issuing private hire licenses. Officers of the what I call outlier local authorities are placed at the disposal of the principal authority and undertake local checks, enforcement. There'll still be the requirement for all the hackney carriage activity in the district. Economies of scale, reduction in fees to the licensees, recharge from the principal authority to each outlier district for the work that's undertaken. So all the complaints about we're doing another authority's enforcement work, you're still doing the work, but at least you get recompense for it. And instantly you have national standards because there's only one standard. Now, people say, well, it won't be the highest standard. Now, of course, it won't be the highest standard, but it'll be a damn sight better than the lowest standard. And sometimes you need to make compromises to achieve a goal. I'm not going to go on about it any longer. I'd encourage you to have a look at the article in the journal and just have a think about it. It's an opportunity for local government to say, central government has let us down. Central government is clearly not interested in this. Here's local government actually doing something big, something imaginative to address what is regarded, I think, with some justification, as being a threat to public safety. You wouldn't have the situation where a person is revoked in District A and then licensed in District B. And that still goes on despite the NR3S. Right, enough said on that, Stephen.
Yeah, well, no, I'm going to say a little bit more about it then. Okay. And I'm going to pick up on Greg's question, which has been nestling in the Q&A for about 17 minutes. It's a short question. Does this mean that localism is fundamentally incompatible with a trade which can undertake journeys anywhere in the country? No, I don't think it does. Yes, the decision making may be at a higher level, either 70 under the levelling up proposal or 1 under the button plan. But this is not about decision making, and decision making isn't the heart of localism. This is about public safety and nothing else. And if that is the means of achieving the highest standard of public safety in this transport system, then it should receive universal support and we wouldn't have the horrendous cases that are the only hack and private hire cases that make the headlines, where a bad apple has been discovered having got through the system. National standards is the way to resolve that. If there is one standard that applies throughout the whole of the country, and I'm sorry, Wales, but we don't know what your government's going to do on this yet. And they seem to be taking an awful lot of time to consider and potentially make their minds up. But if this delivers, then if this delivers a higher standard of public safety, then it will get my vote.
I'd also just say that I think I agree with everything you say about localism, but to be honest, one local authority next door to another local authority being unable to agree even on the simplest elements of a policy, to my mind, is abject failure of localism, to be quite honest.
Yes. It's a bit NIMBY as well, isn't it? Because I know elected members think they are the ultimate authority for their area, and I don't disagree. That is the democratic system that we have. But I'm sorry, hack and private hire licensing transcends that level of decision making.
Right. Okay, so moving on. Oh, there's another question, I think. My system is only picking these up quite slowly. Could I put a link to the article? Yes, I will do. Right, another question. An FOI reveals 36,000 private hire drivers are licensed with Wolverhampton. They make money on this, but what's the point if, hold on, they can't spend this outside the realms of licensing? I'm not convinced they make money. I think they cover their costs. They have an enormous staff. They have people undertaking enforcement in all sorts of parts of the country. And why they do it, you would have to ask Wolverhampton. But I think the DFT reckoned that 17% of private hire licenses are issued by one authority. They didn't name them, but we can all guess who it was. So they are, to an extent, cornering the market. Stephen, would you like to just pick up on the next point, and I'll find this link and put it in the chat.
What's the next point?
Tension between protecting the public and protecting the rights of drivers.
I don't see that one yet.
Okay, righto. No, not in the chat.
What I was going to say on that, again, it's a Hull example. The Hull Authority has recently granted an operator's license to Uber. And Uber's pitch was that they are looking to recruit up to 250 drivers, all of which will be licensed by Hull. So that means that existing Hull licensed drivers can sign up to work with Uber, but also new drivers will have the option of signing up to work with Uber. That will reverse the trend that my city has seen over the recent years of Hull resident drivers getting themselves licensed in Wolverhampton. And we're seeing it already. But that has been misinterpreted as Uber are suddenly going to start operating in the city with 250 brand new drivers. Where are they going to get those from, ladies and gentlemen? It is simply misinterpretation of the facts. They are looking to recruit 250 drivers. I suspect the majority of those will be currently licensed and currently licensed by the city where Uber intend to operate. So don't believe everything you read in the press. Who said that first? Probably the inventor of the printing press. Right. So we've done that one. We've done George's question. Jim's posting the link. There's something else there now, I think. Single licensing authority, either at county or national level, will see the end of virtually all local PH operators, as they will not be able to compete with the likes of Uber or Bolt. I'm not convinced that that is right, with respect, Dave. What it will achieve is the national standards and uniformity of process. And competition will sort out the rest. There is absolutely no reason why a local PH operator cannot compete against theirs. And remember that in the line of Uber litigation, Uber drivers have got worker status, they've got paid holiday, they've got all the other benefits that go with worker status, and they'll just have to compete. But I don't see that would mean the end of local PH operators. Not anywhere near that. Jim?
No, I agree. You know, Jim's Cars Hull could still be licensed by Wolverhampton, still advertise in Hull, have its drivers and vehicles in Hull. They're local Hull drivers. They're people that the residents know and like. It's a firm that has been in existence for a number of years. It's got a good reputation. The fact it's licensed by Wolverhampton, exactly as Stephen says, isn't going to affect the fact that it's providing decent public service journeys to the public. And I think that the fear of that people have of Uber and Bolt and Vizu, I personally think is unfounded. I'm a bit with Stephen on this. Uber have caught the public imagination. My children don't talk about getting a private hire vehicle, even though their father had written the bloody book. They talk about getting an Uber. It's become like Hoover. You don't vacuum, you Hoover. You don't get a private hire vehicle, you get an Uber. Not out in the sticks where I am, but certainly in the cities. Even if it isn't an Uber that turns up, or even isn't an Uber you booked with. So I think the whole private hire world is changing. You've got Vizu, who seem to be acquiring private hire firms at an extraordinary rate. Their operating model is almost identical to Uber. So I think the private hire industry is in a state of flux. There's no doubt about it. 10, 15, 20 years ago, you have lots of little private hire firms in your district, possibly running, maybe 24 vehicles, if that'd be quite a big one in a lot of places. You've now got firms running 2,000 and 3,000 vehicles. So it is an area of the trade that is evolving. There's a question here from an anonymous user. Do you think central government, DfT, could set up and implement a national licensing centre under new legislation running alongside the DVLA? Yes, and I think the sun will rise in the west. I mean, honestly, they've done nothing on legislation. There's not a snowball's chance of this happening from central government. And without making too much of it, one of the things about my suggestion is it doesn't require any new legislation whatsoever. It's all there, just waiting for us to take it. So
they should have done that already, also, because it is. And that was one of the recommendations of the report that Jim referred to earlier. One of the 50 odd that they haven't taken up. That there should be a central database, and it took some considerable time and prevarication on the part of government before NRS 3, as it's now called, was recognised as a database that was capable of performing a national function. And about time too, they said, oh no, we're going to do our own. And then they found their own idea was too difficult, and they looked at NR3 and said, that works well. Yes, it does. So add suspensions to it, which is where the S comes from. We'll use that. And it took them months and months and months, if not well in excess of a year, to actually recognise that as being part of the fulfilment of that recommendation from the report. But there are limitations to NRS 3, even though it is good, and I hope you are all using it, because making entries on it is now law, thanks to a private members bill in 2022. It is good, but it has its limitations, and I'll give you a recent example in my own experience. A decision was made to revoke a driver on proper grounds in January of this year, and the driver, as they are entitled to, lodged an appeal against that revocation. And of course, the law allows that driver to continue as if the licence was in full force and effect. The magistrates managed to set a final hearing for that appeal towards the end of September of this year. Some 2 weeks or so after the revocation in January, information was received that the same driver had been up to an awful lot of more serious activities than he had been revoked for. What do? Well, you initiate another, inverted commas, review of that license, and you just hope that the decision will be made that any revocation is then within immediate effect, because that effectively overrides the existing appeal. But we've now got that driver's badge, the appeal has been withdrawn, and he is off the road and the public is safe. The only thing we can put on NR3S is the January revocation. There is no provision on that register for the additional information arising after that revocation decision. That's a problem which NRS 3 needs to work on, if we are going to have a universal database of absolutely everything for the protection of the public.
Yes, the other thing on that is drivers who surrender their licence before action is taken by the local authority. And of course, that wouldn't go on the NR3S either. I'm firmly of the view, and I think I did an article again in a journal somewhere, that there's no provision to surrender a licence. That licence lasts until it expires or is revoked. And I don't think there's nothing in the legislation about surrender, and you can contrast that with one or two other licensing regimes. So my view is that if an authority is on the cusp of taking action against a driver, do not accept a surrender, take the action and get it on the NR3S, because otherwise, ultimately, you're letting everybody else down, because that bloke will then shove off somewhere else and appear apparently unblemished. It may be a lady, may not be a bloke. I just realised I always tar them with the same brush, but by no means always the case. And if I can just mention one other point, the perception we all have, I think, is that the drivers are the problem. We're here to protect the public, and we're protecting them from the drivers. I think it's very, very important to recognise that the drivers are the public as well. You don't stop being a member of the public just because you become a driver. And again, arising from a discussion at yesterday's session in Milton Keynes, and it was the open session, so I'm not giving any secrets away. There was a police officer there from Avon and Somerset. He's one of only two, what he calls himself, taxi cops in the country. He solely deals with taxi licensing, funded by the local authorities that he works for. And he's been doing that for 8 years. And over the time, he has monitored the crime reports, and he has found in that area, which is South Gloucestershire and Bristol, that there are consistently 3 times more assaults and problems that drivers experience than are perpetrated by the drivers. So it's an easy fallacy to fall into, and I'm sure I've been guilty of it as well over the years, of thinking we're here to protect the drivers. We're not. We're here to protect the public, and that includes the drivers. And I just thought that was a very interesting statistic, which is actually, backed up by evidence. Right, there's another new post here.
I think the answer to that new one about tier 1 authorities is, well, national standards would resolve that.
Yes. What I said about drivers not having a mechanism to surrender, is that the same for vehicle plates? Off the top of my head, I don't know. I'd have to have a look. And then there's another one about the NR3S. Isn't the benefit that by contacting the licensing authority, you can get the correct up-to-date information? As the information on NR3S could include convictions that later become protected, preventing unlawful disclosure. Yes, I think it is, don't you, Stephen?
Yes, I agree. The point is, if you do what you should do, having discovered there is an entry on NR3S, relating to who you are dealing with at the time, the idea is that you then contact the posting authority to get what it would be referred to as the soft intelligence. Similarly, as DBS sometimes include things like that. So do use NR3S regularly and properly, please. Mm-hmm. Yes, Rachel, the same happens if a driver hands in his badge. That's technically a surrender. Mm-hmm. You ever suspend or revoke a license with immediate effect at committee under section 61(2) in the interest of public safety. My personal experience is that such a decision rarely goes to committee, because my licensing manager has delegated authority to suspend it, and usually he hasn't got delegated authority to revoke it. So if it was a revocation as opposed to suspension, that would go to committee.
And on that, I would say my view has firmly been for, since we got those powers in 2006, that power should be delegated, both suspension and revocation, to an officer. And I always suggest in consultation with the chair or deputy of the regulatory committee, so that there is not only political involvement, but from the point of view of you as officers, there is political support. And I think that's a very important self-preservation concept.
Thank you
and
both
the one
very
that's just
much.
Popped in, yes, I do rate English language proficiency in terms of fit and proper. I think it's part of the fit and proper determination, because you need that proficiency to avoid flashpoints in the road or in the vehicle or on the rank.
And that is recommended in the statutory standards guidance issued in 2020 by the DFT.
Thank you very much. I think we've time for one more question, and that's from Richard, and then we're going to wrap it up. Richard O'Sullivan asked, if a driver is revoked by one authority who chooses not to appeal because of an introduction of a local operation by first authority and applies for a license at another authority, can he seek to dispute the basis of the first revocation when revoked by the second authority if first revocation only discovered after the grant by second authority? That's a bit of a tongue twister.
What's the local operation bit, Richard? I don't quite follow that. My answer is he's going to be out of time to dispute the first. That's my initial reading of your question.
Thanks very much for that. I think that's all we've got time for. It's clearly a topic that could we could talk about for hours and hours and hours, but we don't have that luxury available to us. So all it remains for me to say, thank you all very much for your participation and engaging conversations. We've very much enjoyed listening to them, and some very interesting points raised and nicely dealt with by Jim and Steve. So thank you very much for that. And thank you all for attending. We will be sending you out a copy of the recording when it's available, together with the links to other content and further reading. And enjoy your lunch and the rest of the day. Thank you very much indeed.
Thank you. For completeness, if you're still there, paragraph 6.14 of statutory standards recommends English language proficiency, both written and spoken.